On July 18th, outside a convention center in downtown Miami, United States Marshals arrested two celebrity brothers on a sealed extradition warrant. That warrant did not come from an American prosecutor. It came from the United Kingdom's Crown Prosecution Service. The brothers in question, Andrew and Tristan Tate, hold a citizenship and therefore passports in both countries by birth. And for 2 weeks, the internet has been asking and speculating how extradition works when somebody has multiple passports. Almost all of it is wrong, and we have Hollywood to thank for that.
I have 7 passports.
Now, you are probably not a dual national facing an international warrant, but this information applies to anyone who travels internationally. The same rules deciding the fate of the Tates are the same rules which decide what happens to you if you were ever arrested in a foreign country. And almost everyone watching holds specific beliefs about how it is handled, most of which are wrong. The laws governing your rights are different in 4 specific ways determined by the country you are physically in, and I'll make sure you understand them all. I will also show you the one man who beat this whole system, 36 years free and on the run, never a citizen of the country that was protecting him. And at the end of it, he got on a plane. He flew back to prison voluntarily. So to understand why he did that, you need to understand a whole lot more about this entire subject. Now, some quick framing because this topic attracts a certain kind of comment. This video is about extradition law as it applies to dual citizens with multiple passports. It's about the gap between what people believe and what a second passport and the treaties involved actually say. I will walk you through the mechanism. I will show you which countries protect their citizens and why, as well as which ones don't. And I will explain why in the Tate's case, holding 2 passports will do nothing at all for them. Now, this is not a guide to avoiding prosecution. No country on earth exists to shelter you from a criminal charge. And by the end of this, you will understand why the handful of people who did stay free paid an extreme price to do so. I'm also not going to discuss the allegations. That isn't the theme of this channel. Both men are entitled to contest every part of the allegations, and their lawyers have said they intend to fight the process and appeal it. The authoritative sources on where this stands are the U.S. Department of State, the U.S. Department of Justice, and the Crown Prosecution Service. Everything else I'm about to tell you is extradition procedure, not an opinion about anybody's guilt or the merits of the case. Now, the passports. Andrew Tate has claimed on camera that he holds 7 passports.
I have 7 passports.
He has never specifically said which ones. The verified total as it stands at the recording of this video is 3 passports. He is a citizen of the United Kingdom and the United States, both by birth, which nobody disputes. And according to an investigation published by the OCCRP, he also holds citizenship of Vanuatu obtained in 2022 through that country's investment program. The other 4, if they exist, have never been documented. So, first, holding several citizenships is legal and it's actually pretty ordinary. I help people do it. Millions of people do it worldwide. Millions of people have dual passports. You might even have some in your family. Most multiple passport holders are dual career couples, families split across 2 countries, and people whose birth passport limits where they can work. So, set aside the movie version where a stack of passports means that somebody is up to something nefarious. That's not what most of these are for, and that's not how to describe people who hold them. What you need to look at are the mechanisms in play, because I get asked constantly whether a second passport stops an extradition, and the premise behind that question itself is wrong in a very specific and interesting sort of way. So let's take Vanuatu, since it is the one currently on the table with this case. Vanuatu has no extradition agreement with Romania, the country where Andrew Tate and his brother live. So, if your legal exposure sits in Bucharest, Romania, and you are standing in Port Vila, Vanuatu, there is no mechanism for that extradition to occur. Nothing to file, nobody to file it with. But Vanuatu does have a long-standing extradition agreement with the United Kingdom. The same passport, the same person, but a completely different answer to the extradition question, and it's entirely because it comes from a different capital city. That's the first thing that people miss. There is no such thing as a passport that protects you. There are only specific pairs of countries with specific arrangements between them that create different procedural outcomes, and those outcomes change each time one of the countries involved changes. The second thing is what makes Andrew's multiple passport discussion academic. He was not in Vanuatu when he was arrested. He was in Miami in the United States. Every protection we are about to discuss functions in exactly one place, inside the borders of the country granting it. Vanuatu's foreign arrangements govern what happens in Vanuatu. They have no effect at all on a federal courthouse proceeding in Florida. One more detail I want you to keep in mind. That Vanuatu citizenship dates to 2022. The conduct alleged in the British charges runs from 2010 to 2017, before that 3rd citizenship was granted. So plainly, because it applies to the whole subject, If Andrew Tate has 7 passports, it changes nothing. He could have 70. What determines the outcome is the country that he is physically standing in when arrested, and of course, which country is asking for the extradition. Everything else is just a decoration. Now, when somebody says the word extradition, people immediately think of armed government agents grabbing a person off the street, throwing them in cuffs, driving them to an airport, and stuffing them into a plane bound for a foreign shore. The reality of the situation, though, is a lot less cinematic. It has 2 phases. Phase 1. Extradition is not only a police operation. Nobody grabs you off a street corner and puts you on a plane. You are detained until you can appear in court, the same as any other criminal proceeding. It is a judicial proceeding, and it happens in the country where you're physically standing at the time of arrest under that country's rules in front of that country's judges. In the United States, it runs on one statute, Title 18, Section 3184. A requesting country, in this case the United Kingdom, files a request. A U.S. federal judge holds a hearing, and that judge answers 4 questions to determine the eligibility of the accused for removal. Question 1. Is there a treaty that covers the offense? If there is no treaty, there is no mechanism for removal. The judge has no power to certify anything without one. We come back to this later because it's where one of the most pervasive internet mythologies regarding this lives. Item 2 that the judge will examine, dual criminality. This means that the conduct has to be a crime in both countries, which stops a nation using extradition to enforce its laws in another country. 3. Is there sufficient evidence? Sufficient evidence means only, is there enough to justify the charge? Now note carefully what that is not. The judge is not asking or going to determine whether or not the person is guilty. Guilt, innocence, motive, the strength of the case, all of that gets decided later in the requesting country at an actual trial, not at the judge in Miami's courthouse. That distinction confuses almost everybody because people assume the extradition hearing is where you fight the accusation. It is not. It's where you fight the transfer. 4. Is there an applicable exception to the treaty in force? The big one is the political offense exception, and it is a real long-established rule. A country can refuse to extradite somebody for a crime that is political in character. It exists so that nations can stay neutral in each other's internal conflicts. Then, if the judge certifies all 4 of those items, the accused moves to phase 2, a step that most people don't realize exists. The judge does not order anybody onto the plane. The judge only answers a legal question. The decision to hand a person over belongs to the executive branch in the United States, and that means the Secretary of State, a position currently held by Marco Rubio. Those are 2 separate and distinct phases, a judicial one and an executive one. That matters enormously later. Now, if this kind of information is useful or interesting to you, the rest of this channel is about the upside of international living, the lifestyle, the culture, the opportunities that come with moving abroad. We publish new videos every week. Subscribe to make sure that you catch them all. Now, I can hear people screeching that there are certain countries that sometimes do not extradite. They're sure of it. And you're correct, there are. And they are a source of a lot of the Hollywood misunderstandings. The mythology gets the existence of the rule right, but does not accurately explain how it applies to a person accused in cases such as the Tate brothers are. When it comes to extradition worldwide, all countries fall into one of these 4 categories. 4 different sources of protection, but they are not all equally strong. Now, Tier 1 in worldwide extradition is the most ironclad prohibition on extradition. It is an explicit constitutional prohibition. It is written into the country's founding documents, which means that the government cannot waive it, cannot negotiate around it, cannot carve out an exception for a friendly ally. Countries such as Austria, Estonia, Germany, Greece, Poland, Portugal, they all have it in their constitution. Brazil as well forbids extraditing Brazilian citizens, including naturalized citizens, as long as the offense happened after they were naturalized. As well, Venezuela has a blanket prohibition under Section 69 of their laws, and Russia's sits in Article 61 of their constitution. Crimes committed before naturalization are still eligible for extradition in all of these countries. Now, the strongest thing on the list is also narrower than it sounds, and I'll show you why in a couple of minutes. One note on the European prohibition. Several EU member states have amended their constitutions to allow surrendering their own citizens to other EU countries under the European arrest warrant structure, while keeping the prohibition for everywhere else. So, for example, a German citizen cannot be extradited to the United States, but they can be surrendered to Spain. The shield has a European-shaped hole in it. Now, Tier 2 in worldwide extradition is a statutory prohibition. It's the same practical effect as Tier 1, but it's a weaker foundation. It sits in ordinary legislation, which a parliament can amend. Countries such as Chile, France, Lebanon, Qatar, Slovenia, these countries practice this option. Israel belongs here too, with the addendum that Israel will also not extradite its own nationals unless the offense was committed before a person became a citizen. Now, Tier 3 in worldwide extradition is a treaty clause, and this is the one that fools most people. A lot of extradition treaties contain language about nationality. Skim it and it reads like protection. Read it closely and it says something much weaker. The American wording of the statute says that there is no obligation on the United States to extradite its own national, but that the executive shall have the power to surrender that national if it deems it proper. In this case, on the findings of the judge that we covered in the 4 points above. That's not a shield or a guarantee like the first two in this list. It is only permission to refuse. It gives the government the option to say no at their discretion and nothing more. So the outcome depends on whether that government has something behind the clause, a Tier 1 or Tier 2 rule, or whether it just has discretion and no particular reason to use it. Now, Tier 4 in worldwide extradition is no treaty at all. This is the biggest source of real-world insulation, and it's not a protection so much as an absence. If there is no treaty between the two countries, then the judge has no authority to certify a removal because that authority would come from the treaty itself. Countries with no extradition treaty with the United States include Russia, China, Iran, Cuba, Venezuela, Belarus, North Korea, Vietnam, Indonesia, Kazakhstan, Mongolia, Ukraine, Taiwan, most of the Gulf states, most of Africa, and most of the former Soviet socialist republics. Now that said, no treaty does not mean no removal. Countries with no American treaty have handed their people over anyway through deportation, through immigration enforcement, or through informal cooperation. None of that requires a treaty or a hearing. Indeed, Interpol notices stay live in all 195 United Nations member countries regardless of treaty status. So you could still be detained at the border by a country that would never have extradited you based on that notice alone. When you are traveling to a third country, your presence there is a revocable privilege, and your immigration status is a separate question from your citizenship. For more on how that works, check out my Reckless Ben video linked in the description and right here as well. Now, then there's the treaty wording that nobody expects. Some countries have no nationality bar whatsoever in determining whether or not somebody is eligible for removal at the request of a foreign government. The largest practitioners are the United States, the United Kingdom, Australia, Canada, Ireland, New Zealand, and India. The entire common law world extradites its citizens as well as third-party citizens within its borders as routine policy if the judicial review finds that the treaty terms are satisfied, which should tell you something about where this case is heading. Andrew and Tristan Tate being American citizens has no effect on the proceedings. Being Vanuatu citizens has no effect on the proceedings. All accused persons in the United States facing extradition have the same rights. No more, no less. So here's how this talk of multiple passports, dual citizenships, treaties, and judicial processes applies to you as well as to the Tate brothers. So swap this for what Hollywood has been pushing in its movies. So rule 1, protection is territorial only. German citizenship stops Germany from extraditing a German citizen physically in Germany. It does nothing for that citizen in Miami or Bangkok or anywhere that is not Germany. The protections need two things at once: your citizenship and your physical body inside the country that issued it. You step out and you are a foreign national with a red notice attached to your name. Rule 2, nationality in all of these cases is measured at the date of the offense. Treaties and constitutions say this explicitly. The nationality of the person sought is their nationality on the date the offense was alleged to have been committed. Israel's statute says the same thing from the other direction, protecting nationals except for offenses committed before they became citizens, which means criminals cannot acquire protection after committing a crime to evade consequences. A passport you buy this year does nothing about what you did last year. Now, bring that back to the date I gave you. Andrew Tate's Vanuatu citizenship was granted in 2022. The conduct alleged in the British charges runs from 2010 to 2017. Even in the imaginary version of this story where Vanuatu had a nationality bar and he was standing in Port Vila when the request arrived, the dates alone sink any protections that would have been afforded by that citizenship. He was not a citizen of Vanuatu when any of these crimes are alleged to have been committed. He would be removed at the request of the United Kingdom, same as anyone else. And indeed, many countries go a step farther in preventing the criminally inclined people from becoming citizens. Several countries, such as Germany and Brazil among them, can freeze or deny a citizenship application outright when there is a pending international proceeding against the applicant. The door closes exactly at the moment where somebody might want to walk through it for nefarious purposes. That is by design, and I would applaud that. Now that we have all of this information, let's trace the history of the Tate brothers' international problems. Again, they are innocent until proven guilty, which has not occurred at the time of this recording. Quick setup, because people keep asking why two men facing proceedings in Romania and the United Kingdom were standing in Miami in the first place. The Romanian indictment was sent back to prosecutors over procedural and structural flaws, which paused that case, and the travel restrictions imposed upon the Tate brothers were removed, allowing them to again resume international travel. That is a separate matter from the British charges, and not involved with the extradition request now in the hands of the US government. The British charges are the live issue at hand. Andrew Tate faces 42 charges. Tristan faces 17. The alleged conduct spans from roughly 2010 to 2017. And I'm not going to enumerate them here. I'm not going to characterize them. Go to the Crown Prosecution Services for statements if you want the specifics from the actual source. The 4-point judicial review of the extradition in this case begins with, does a treaty cover it? Yes, the United States and the United Kingdom signed a new extradition treaty in 2003, and it came into force in April of 2007. And that treaty has no nationality bar. The modern American template goes farther than staying silent on the question. It says that if the conditions are met, the extradition shall not be refused based on the nationality of the person sought. So the American passport is explicitly not a defense in this case. There is a historical footnote that I love as well because it shows how close this came to going the other way. In 1936, the Supreme Court of the United States decides a case called Valentine against the United States. 3 American citizens were wanted by France, and the court held that the executive branch had no power to extradite anybody except as granted by treaty or act of Congress. The 1909 treaty with France said that neither country was bound to hand over its own citizens, and the court read that as American citizens being carved out of the deal entirely. No implied discretion, nothing. So Americans were unextraditable for a while, but Congress later passed legislation permitting the extradition of US citizens where a treaty is silent, and then that door closed. The protection that people imagine that they can purchase today is a protection that Americans actually had, but was legislated away. Items 2 and 3 in the 4-point checklist, dual criminality and the evidence standard, are not where this particular fight for the Tates is going to happen. The conduct is criminal on both sides, and American criminal law descends from English criminal law. You will hear people argue against the treaty's evidentiary standards that they are lopsided in Britain's favor. That was previously a common attempt at a defense, but an independent review by the Baker Commission, which was commissioned by the Home Secretary of the United Kingdom, concluded that there was no significant difference between the two countries' tests for removal, therefore arguments could not be accepted on those grounds. Which leaves item 4 as the exception that the Tates are most likely to focus on. And this is where their actual defense is being built. But a lot of people are misreading it in this case. The political offense exception protects offenses, alleged crimes, that are political in character. It does not protect defendants who are political figures. Those are different things, and that difference is what will decide this case. In Andrew's case, he has talked about launching a political party and claimed that he has political enemies or believed that the prosecution is politically motivated. That's what their legal team is asserting, and he's made that comment several times. But that does not convert ordinary criminal charges into a political offense. To get there, you need something specific with evidence to back it up, not broad claims about your perceived bias. And that exception was narrowed decades ago as well to exclude specifically violent crime, which removes most of the ground that the Tate brothers would like to stand on in this case. So my read is that the exception argument is unlikely to be successful. But then after the certification, after the judge certifies that they are extraditable, the final surrender decision belongs in the hands of Secretary of State Marco Rubio. And that discretion is unreviewable. No court procedure exists to review Marco Rubio's decision as Secretary of State. Which is why you see a lot of the online campaign right now is aimed at the Secretary of State rather than the courtroom. And on that law, the campaign is right about one thing. The Secretary of State can say no. Our historical research indicates that successfully fighting extradition is not likely to happen because since this treaty came into force, no American court has ever refused certification on a British request. There has been exactly one refusal at the executive level, and it was specific and unusual. In January of 2020, the State Department declined a British request on diplomatic immunity grounds involving the wife of an American intelligence officer and a fatal road collision. She was later prosecuted remotely and convicted in England. That's the only refusal of any kind during this treaty era, and diplomatic immunity is not an argument available to the Tate brothers in this situation. Then there's the structural reason, which I find more persuasive than anything about any particular official. Look at the traffic. Figures covering January 2004 through June of 2014 record 173 extradition requests from the United States to the United Kingdom against 65 times that the United Kingdom requested somebody from the United States. A parliamentary answer confirms that 133 people were successfully extradited to the United States from the United Kingdom since that treaty entered into force. The United States asks for roughly 3 times the alleged criminals that the United Kingdom is asked for. That imbalance sets the incentives. Any refusal establishes the precedent that the United States will find itself on the wrong side of far more often than the United Kingdom will. Saying no here would be cheap once and expensive forever. This foreign policy has been true for over 20 years, regardless of who is holding the office of the US presidency as well. Add to that, whatever you may think about the current Secretary of State or the executive branch, Marco Rubio ran for president in 2016, which is a matter of public record. It is not a stretch to think that a person who has sought that office once might consider doing it again. He has nothing to gain and everything to lose by blocking this extradition. Optics matter in politics. Though the structural argument does not need to be a personal one, the numbers alone explain the most likely outcome here. It is also likely that Latin America has incredible and untapped opportunities available to you right now. Take a look at this video that I made comparing Panama, El Salvador, and Paraguay, 3 of the most popular Latin American options. I live in Latin America as a permanent resident, and all 3 of these countries allow you to obtain a second citizenship and a passport should you want one. Just stay out of trouble when you get it. So that's the law as it applies to the Tates. And now I'm sure you want to hear about the man who actually beat this situation. So let's go back to 1963. A gang robbed the Glasgow to London mail train in the United Kingdom in what the British papers termed the Great Train Robbery. Ronnie Biggs played a minor role in that robbery and was sentenced to 30 years but escaped after 15 months. He had plastic surgery in Paris and then in Australia. By 1970, he was in Rio de Janeiro, Brazil. He stayed free for 36 years, but he was never a Brazilian citizen, not once. Every single thing that protected him came from somewhere other than a passport or a nationality. First, Britain had no extradition treaty with Brazil. That's tier 4 on our list from earlier. There was no mechanism. Then in 1974, a Scotland Yard detective tracked him down in Brazil, and when the Brazilian government moved to deport him, he fathered a son with a Brazilian woman, and Brazilian law prevents his expulsion as the father of a Brazilian dependent. Family ties, not nationality, blocked his removal. To make it a bit more awkward, his wife back in Australia had to divorce him to make this strategy work. Then, in 1981, a group of men kidnapped him from a Rio restaurant, stuffed him into a duffel bag, and shipped him to Barbados, intending to hand him over to the UK authorities. But Barbados also does not have a treaty with the United Kingdom either, so he was free to travel back to Rio. And then finally, in 1997, the Brazilian Supreme Court rejected a British extradition request outright because the statute of limitations had run out on Brazilian law to make that request. 4 separate mechanisms, no treaty, just family ties, no treaty again, and a limitations bar. Not one of those was a second passport protecting him like Andrew Tate seems to think that things would work. So it worked for him, but here's what it cost him. He could never leave Brazil. He was a tourist attraction selling t-shirts on the beach to people who wanted a photo with the famous Fugitive, because his share of the robbery was spent on plastic surgery and life on the run inside of the first few years of his freedom. He watched his family from thousands of miles away, unable to join them. And in the end of it all, in 2001, sick, broke, and out of options, Ronnie Biggs got on a plane and flew back to the United Kingdom voluntarily, where he was arrested the moment he landed. He would go on to serve 8 more years of his sentence and be released in 2009 on compassionate grounds, unable to speak due to illness and not expected to recover. He would die in 2013. 36 years of sunshine, and he chose a cell at the end of it all because the sunshine had become its own kind of prison. Now you know, as the Tate brothers are discovering, a second passport is a door to opportunity and perhaps a fantastic new lifestyle for you, not a shield. It works in one country if you are standing inside that country. It does nothing about what you did before you obtained the passport. And where a country does refuse, refusing does not close the door on other options. No country on earth exists to shelter you from criminal charges. They write their own rules for their own citizens and their own sovereignty. And if you ever land on the right side of one, you are tolerated as a guest in a very small room. Ronnie Biggs can tell you what that was worth after 36 years of living it. The people who get this right were never chasing loopholes. They understand the rules before they needed them, picked a country for the real and correct reasons, and built something they didn't have to run away from. For where this case stands on any given day, go to the State Department of the United States, the Department of Justice, or the Crown Prosecution Service for official updates. Remember, the right information makes it all possible. I'm Brad with Evolution Expats, and I'll see you in Rio.